Greetings everyone. Today I'm going to talk to you about Section 423 of the Criminal Code of Canada, Intimidation, and how it applies to WorksAfe New Brunswick. So let's look at Section 423 of the Criminal Code. It says, everyone is guilty of an indictable offense and liable to imprisonment for a term of not more than 5 years, or is guilty of an offense punishable on summary conviction who, wrongfully and without lawful authority, for the purpose of compelling another person to abstain from doing anything that he or she has a lawful right to do, or to do anything that he or she has a lawful right to abstain from doing, A. uses violence or threats of violence to that person or his or her spouse, or common law partner, or children, or injures his or her property. B. intimidates or attempts to intimidate that person or a relative of that person by threats that, in Canada or elsewhere, violence or other injury will be done to or punishment inflicted on him or her or a relative of his or hers, or the property of any of them will be damaged. Now, as you can see, there's more to Intimidation 423 than A and B. There's C through G. However, C through G do not apply to WorkSafe New Brunswick. Therefore, I will not be covering them in this video. If anyone would like to see a video covering these aspects of intimidation, please leave a comment and I will do the best I can to accommodate. So, looking at A and B, I'm going to start with A and I'm going to break it down. Well, as you can see, the main thing of A is violence or threats of violence. So what we need to look at from a legal standpoint is what is the definition of violence and what is under the violence scope. So for the definition of violence, we will look to case law. What I have on the screen now is a case in the Quebec Human Rights Tribunal in 2010. This case refers to discrimination based on sexual orientation. However, it does define violence. And it defines violence as verbal, psychological, physical, or sexual. Now, this human rights case is dealing with discrimination based on sexual orientation. However, there are multiple factors under the Canadian Charter of Rights and Freedoms in which you can be discriminated against. So let's take a moment to look at the Canadian Charter of Rights and Freedoms. Equal rights. Every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Now, comparing a human rights case that has sexual orientation as its target to a case that would have physical disability or discrimination based on religion, the same definition of violence must apply in all cases because we have equal right and equal protection under the law, under Section 15 of the Charter. Now, some people may say that they have freedom of expression in Canada, freedom of speech, therefore their words and their actions are justified under the Charter. I'm going to address that next, and we're going to take a look to see if that's the case. In Canada, under the Charter of Rights and Freedoms, everyone has the freedom of expression, which means freedom of speech. However, freedom of speech does not cover violent threats. Violent threats not being covered by freedom of speech can be found in our case law as well. I have a case on the screen from the Supreme Court of Canada in 2012, where it has been ruled, as this court held in Greater Vancouver Transportation Authority, violent expression or threats of violence fall outside the scope of the Section 2B guarantee. It makes little sense to exclude acts of violence from the ambit of Section 2B, but to confer protection on threats of violence. Neither are worthy of protection. Threats of violence, like violence, undermine the rule of law. Now the judge says, as I wrote in dissent in R versus Kengstra, 1990, Supreme Court of Canada, threats of violence take away free choice and undermine freedom of action. They undermine the very values and social conditions that are necessary for the continued existence of freedom of expression. I therefore reject that the violence exception to Section 2B is confined to actual physical violence, without, however, deciding the precise ambit of the exception. Threats of violence fall outside Section 2B guarantee of freedom of expression. So now let's take a look at Regina versus Kenstra in 1990, Supreme Court of Canada. Now this case is referring to the communication of expressions of hatred. However, our reason for looking at this case will be to look at the violence aspect of it and how they discuss violence. So when you see section 319, that's referring to expressions of hatred. Beginning with the suggestions that expressions covered by section 319 fall within the exception articulated by Irwin Toy, which is another case, it was argued before this court that the willful promotion of hatred is an activity the form and consequences of which are analogous to those associated with the violence or threats of violence. This argument contends that the Supreme Court of Canada precedent excludes violence and threats of violence from the ambit of Section 2B, and that the reason for such exclusion must lie in the fact that these forms of expression are inimical to the values supporting freedom of speech. Indeed, in support of this view, it was pointed out to us that the court in Irwin Toy stated that freedom of expression ensures that we can convey our thoughts and feelings in nonviolent ways without fear of censure. As for threats of violence, Irwin Toy spoke only of restricting Section 2B to certain forms of expression, stating at paragraph 970 that, while the guarantee of freedom of expression protects all content of expression, certainly violence as a form of expression receives no such protection. It is not necessary here to delineate precisely when and on what basis of form of expression chosen to convey a meaning falls outside the sphere of the guarantee. But it is clear, for example, that a murderer or rapist cannot invoke freedom of expression in justification of the form of expression he has chosen. So what this means is that even though you have the right to freedom of expression, you do not have the right to violently threaten somebody or to commit violence. The Charter of Rights and Freedoms has a specific goal in mind and what they're protecting you from as a citizen. The Charter is not meant to give you a license to abuse others, because in doing so you would be violating on that person's rights. So in order for the Charter to work, it has to be fair and just. To keep it fair and just, certain things, like violence or threats of violence, do not receive protection from the Charter of Rights and Freedoms. And that is so that we can be protected under the rule of law. So now we're going to look at Regina versus Macrae, 2012 Provincial Court of Saskatchewan. The reason I'm going into this case is because it defines violence pretty well, beyond what we've already looked at. It says, the meaning of violence in this definition must be informed by the entirety of the definition of a serious personal injury offense. A serious personal injury offense is defined, in part, either as an offense involving the use or attempted use of violence against another person, or conduct endangering or likely to endanger the life or safety of another person, or inflicting or likely to inflict severe psychological damage upon another person. Taken together, and especially taking into account the far-reaching meaning of the word safety, these two clauses point to the legislature's intention to cover the very expansive range of dangerous behavior within the term serious personal injury offense. So I'm going to take a moment to go over serious personal injury offense, because you've seen it in the last case that we were discussing. Serious personal injury offense means A. An indictable offense other than high treason, first-degree murder, or second-degree murder involving 1. The use or attempted use of violence against another person, or 2. Conduct endangering or likely to endanger the life or safety of another person, or inflicting or likely to inflict severe psychological damage to another person, and for which the offender may be sentenced to an imprisonment for 10 years or more. Or B. An attempt or attempt to commit an offense mentioned in Section 271, sexual assault, 272, sexual assault with a weapon, threats to a third party, or causing bodily harm, or 273, aggravated sexual assault. So intimidation doesn't fall under the category of serious personal injury offense, because the maximum imprisonment is only 5 years. Therefore, it does not meet this requirement, imprisonment for 10 years or more. However, criminal negligence causing bodily harm carries a maximum sentence of 10 years. Therefore, criminal negligence causing bodily harm is a serious personal injury offense. We're not going to get into that in this video, as this video is about intimidation. However, there will be a criminal negligence causing bodily harm, serious personal injury offense video to come. Now that we've investigated violence and have seen what the definition of violence is in our courts, as well as that it doesn't receive protection from the Charter of Rights and Freedoms, we're going to now look into Section B of 423. It says, intimidates or attempts to intimidate that person or a relative of that person by threats that in Canada or elsewhere violence or other injury will be done to or punishment inflicted on him or her or a relative of his or hers, or that property of any of them will be damaged. So now we're going to look into punishment to see what punishment defines as. For the definition of punishment, the case that I've chosen to use is a British Columbia Workers' Compensation Appeal Tribunal case from 2012. The concise Oxford English Dictionary defines reprimand as a formal expression of disapproval and defines punishment as the action of inflicting penalty on as retribution for an offense, or the action of treating harshly. So here we have the definition of punishment as it is accepted by our justice system. So now we're going to go back to section 423 because we've defined violence and we know how violence applies and what violence means, either physical, verbal, psychological, or sexual. And now that we have the definition of punishment and what it means in our legal system, let's look at section 423 of the Criminal Code again. If you've ever had a WorkSafe New Brunswick employee raise their voice to you over the phone in order to make their point known or to make themselves sound superior, they have actually committed an act of violence against you. And if they did so in forcing you to do something or forcing you to abstain from doing something, then they have violated section 423 of the Criminal Code. Verbal abuse, a lot of the times, is psychological abuse because you have to process mentally the verbal violence that you are receiving, which has psychological effects. That being said, if WorkSafe employee is using verbal abuse or verbal violence against a client, they are also admitting to think of the client's mental safety, the psychological abuse that will be inflicted by what it is they're saying and how they're communicating. The main part of things where WorkSafe violates the criminal code is when they tell you that if you do or do not do something that they're asking you to do or asking you to admit to do, they will cut off your benefits. Essentially, they're threatening punishment upon you because they're threatening to cut off your source of income. An example of such would be if WorkSafe scheduled you to see one of their specialists and your doctor didn't agree with the specialist, hypothetically speaking of course, then WorkSafe could say that you have to see our specialist or we're going to cut off your benefits. Now, if they do that, then they are saying you have to do something that you have the legal right to abstain from doing, or they're going to punish you. And in threatening the punishment, they may also be threatening violence, depending on the way in which they're communicating. Now that we understand what violence and punishment means in dealing with WorkSafe New Brunswick, you have the right to inform them of what they're doing is a violation of the law. So the next time that your case manager yells at you or threatens to cut you off based on something that you're either going to do or you're not going to do that they don't agree with, then you need to make them aware of section 423 of the Criminal Code. As I said in a previous video, ignorance is not an excuse. However, if you inform them and they're not aware that what they're doing is causing you psychological damage or threatening punishment, you may be able to help them come to light of things. In conclusion, section 423 of the Criminal Code is here to protect us from intimidation. You have the right not to be threatened with violence or punishment, and that is your right which is protected under the Criminal Code section 423. It is time that we stand up for what is right and just, and it is time that we, the people, give the government something to fear. Thank you, and have a good day.